In this presentation, we will discuss contract law. At the end of this, we will be able to define what a contract is, describe the law merchant, list and describe the 4 elements of a contract, discuss the reasons for contract law, and list the contracts that must be in writing to be enforceable. A contract itself is going to be a type of an agreement. It's going to be an agreement between at least 2 or more individuals. We have to have, of course, at least 2 individuals or more in order to have a contract. We must have mutual promises between the 2 individuals or more individuals to either do something or refrain from doing something. And that act or the acts that we are either doing or refraining from must not be illegal. So we obviously, because we're talking about law here, we can't have a legal contract for something that would be illegal. So that's basically going to be the idea of the contract. We got 2 or more individuals that are promising to do or not to do something. And we'll talk more about the elements of the contract that under the legal system are necessary in order to make the contract binding. But on the most basic level, that of course is the contract mutual promises in essence between 2 or more individuals. Once we have that mutual promise, then from a law standpoint, we can say that the individuals have a duty now under the contract, and we can then enforce that contract and talk about whether or not that duty has been fulfilled or not, given the mutual promises given the contract. To give the context of the contract, note that it's going to really arise from the business. Business itself is going to have a necessity for contracts because the business people involved, if we're talking about merchants involved within transactions, they're going to need some way to know amongst themselves how to enforce contracts. So from a historical standpoint, the idea of business being business itself and needing to have exchanges and needing to have some kind of format to have those exchanges be more trustworthy, then we would need some type of law to arise, some type of agreement to be formalized so that we can know what could be expected in general when we deal with transactions with merchants. And of course, as we go through time, we know that we'll more formalize some of these contracts so that we can then know what will be expected. And as we know what will be expected, as with the idea of contract law, that will facilitate trust between transactions, and that typically will increase trade, and that is generally the idea, that's generally the good thing. So the contract law, of course, coming up from the practice of trade through merchants looking for a better way to set the system up, and then of course those best practices being finally brought into a formalized legal system, and that's really kind of where contract law is derived from. This concept of law being derived or coming from the practice of doing business is typically a good practice because that really involves people that are in the law, that are working with what the law is needed for. So in other words, the creation of the law when common law or contract law is put into place, and is typically a good practice for any type of law. The people involved in the law, the people affected in the law, or the type of regulations that are going to be enforced are typically the ones that should be involved in making those regulations because they have the most insight as to what will happen in general on a whole. And they have the idea of knowing, well, what would one individual be able to do that might benefit that individual but hurt the practice as a whole. So that type of concept in thinking about multiple people doing business to try to create an environment where business in general does well, as opposed to someone trying to do something that would hurt business in general and help an individual is going to be one concept that is applicable in terms of making law and part of the creation of basically contract law. Of course, this would include a concept of consistency. We want to make sure that the law will be consistent as we think about contracts and the formation of contracts and the enforcement of contracts. We would need some type of consistency in order for people to understand what they would be getting into, and therefore be more likely to enter contracts with the knowledge of what they're expected of and what is expected of the other individual involved. Once we have a set of rules and practices that becomes more formalized, then we're going to need some kind of way to enforce problems in the law. So when someone breaks a certain custom or rule that is going to be generated, of course, then there needed to be some type of way that we can have a system of justice to judge whether or not the practices have been violated. and if so, some way to remedy the situation. As we think of the 4 current elements that must be present in order for a contract to be binding, it's important to think through how this probably would be set up in the process of doing business, and how a business itself is going to lead to the generation of some type of formal practice, and then of course that formal practice being formalized in contract law. So as we go through these 4 elements, we can think through how would this enhance the contracts in general, how would it help trade in general, how do contracts in general help business and help trade, help merchants, and help, therefore, the greater community as a whole. So the 4 components are going to be mutual consent, consideration, capacity, and legality. The concept of mutual consent means that both individuals involved have some type of consensus. There's been an offer, there's been an acceptance, and both individuals, both parties have mutual consent to it. Sometimes this is referred to as a meeting of the minds, so there's a meeting of the minds and a consent to the contract. Of course, when there is not mutual assent, so if we have a contract and we're saying, okay, there's something wrong with the mutual consent component, then obviously if there's something like undue influence, if someone was under duress or something during the signing of the contract, then that would be a situation where we could say, okay, there wasn't really mutual assent on both sides. If it was a mistake, or if there was some type of deception, some type of fraud within the formation of the contract, there wasn't equal knowledge or knowledge that should have been present in both parties for the contract, then we could say, okay, there wasn't really a meeting of the minds in those types of cases. The idea of consideration is the idea that there must be something of value being given up and received by both parties within a contract. A contract means that there's some give and take, there's value in both sides of the contract, there's some type of trade of value. Now, of course, that doesn't mean currency in general or just things. It could be things like time, or just time within or for a service within the contract. But when we look at the elements of the contract, we're assuming that the 2 people going into the contract had a mutual self-interest as they go into the contract, and therefore they're going to provide a good or service and receive a good or service typically in return. So that idea of consideration on both sides of the contract is a component. We can also see, as we look at the legitimacy of a contract, that if one side gave something of much higher value than they received, that may not negate the contract in and of itself, but it might be evidence that something looked suspicious, possibly that the mutual assent, the meeting of the minds, maybe wasn't completely clear, possibly there was something that was not known by the 2 parties, possibly fraud was happening, or maybe there was duress or some type of undue influence involved, because we would think, again, if there were 2 parties that were engaging in a contract with their self-interest involved, which is the idea of the contract, then there would be some type of close equality in some way between what was received. And again, that could change, of course, between the value of something will be different by different individuals, so it's hard to determine the value of something that was given and or received all the time, but we would assume that in the mind of the individuals giving and receiving, we would have something that's fairly equal in value. The next component is capacity. Do the 2 people involved, or the individuals or parties involved in the contract, have the capacity to make the contract, the legal ability to make the contract? Now, typically, we would think that individuals would have that legal ability to make contracts, as the idea individuals can make contracts for themselves. And there are some cases that are the most common cases where we would say maybe there is not an ability to make contracts. For example, minors may not have the ability to make contracts, of course, because they have not achieved the legal age. The concept of the legal age being that someone doesn't have the developed mental capacity and or experience at that age in order to make a contract. There's also, if we have some kind of mental condition or something like that, questions as to whether they have the capacity. If someone is having some type of mental conditions, then oftentimes they'll relinquish that capacity maybe to a caretaker at some point, possibly an elderly individual or something. They may have someone else that would be able to have the binding contracts be made. So there could be questions, of course, in those types of situations as well. And the fourth component is legality. So of course we can't make a contract to do something illegal, and then it wouldn't be a legal contract. So we couldn't make a contract, to harm someone or something like that in a way that would be against the law. That would be a contract that would be illegal and therefore not enforceable. And that's one of the elements if we look at types of contracts or types of businesses that are black, in a black market or something like that. If there was something like illegal drugs or something like that, or gambling, note that those are dangerous. One of the reasons that those are really dangerous situations are that people are trying to conduct business in a market that's a black market, and therefore don't have the benefits that most businesses have of legal contracts, of a code of contract that is thought that everybody should abide by and be held to. So that's going to be a very important component that we need within to be able to trust in trades. So we have to have that, of course, legality in order for a contract to be enforceable by the law. Now, of course, the idea of the contract of these elements of the contract is to be able to determine whether a valid contract has been put in place. And once it has, then the individuals involved have a duty to the contract. And then if there's a breach of contract, we can then see how are we going to rehabilitate the party that has been injured through the breach of contract. Typically, when we think about how we're going to compensate the injured party, we are going to try to monetize the amount of dollar-wise that has been lost through the breach of the contract. And typically, we will want to reimburse the individuals for the losses that have been incurred. That would be a compensatory damages. It is possible, however, to have incidental damages as well, and that's the idea of making up or paying for any expenses by the victim to prevent additional losses. So compensatory damages are to rehabilitate damages that have happened already for the breach of contract. Incidental damages are really looking into the future to see if we can prevent any additional losses and look to compensate for that. We also have the concept of punitive damages, which would apply here as well. So it could be that we would apply punitive damages, and remember, those are going to be damages above and beyond what would be compensating for the loss that happened through the breach of contract. And the point of that typically is actually to actually punish the individual that breached the contract in order to deteriorate the likelihood of that happening again, both by that individual and kind of to set a message that there will be punitive damages. It's not just going to be a loss to the general public as well, to try to lower the risk. And note, this is kind of important in certain areas, because obviously if the loss of breaching the contract is fairly low for some individuals, and the gain of breaching a contract can be high. So in other words, if we are to go into a contract and have a loss that wouldn't be very likely if we breach the contract, and if we do breach the contract, it's fairly low for us, whereas the gains of having that ability to breach the contract are high, then that increases the likelihood of people not adhering to contracts. So we want to have a deterrent effect, and if the damages aren't enough to really deter people from breaching the contract, that's when we would need, just from a legal standpoint, to have the damages be high enough so that people don't go into contracts with the idea that they don't have much care if they keep the contract or in alignment with it or breach it in the future. Because contracts are so important to business, so important to trade, so important to commerce, we have the Uniform Commercial Code, the UCC, has a set of laws designed to govern pretty much all of the commercial transactions. This, of course, will cover many, many types of contracts, because business contracts are going to be very prevalent within. But note that we do have contracts that would fall outside of business contracts, and therefore fall outside of the Uniform Commercial Code, the UCC. Many of these contracts may be handled or covered by common law rather than be covered by the Uniform Commercial Code. It can at times be confusing as to whether something is an agreement or a contract. And many people, when they think about this, they think that the major difference is that a contract is in writing and something else, an agreement, would not be. And note that that's not one of our four elements of a contract. So it's not the fact that something is in writing that's going to distinguish whether a contract is a contract or not. A contract must have the four elements of mutual assent, consideration, capacity, and legality. Now, there are some contracts that will need to be in writing. We'll discuss that, but just note that that isn't one of the 4 elements, and therefore we have to kind of think about, well, what's the difference between an agreement and a contract? Note that social agreements, like an agreement to meet for dinner or something, when considering the idea of contracts, we need to understand the concept of agency as well. Agency is going to be the concept that we have one individual, possibly if we're talking about an individual that works for a business or a corporation, that is able to make agreements for the organization. And we can see how that will be applicable when we think about contract agreements, especially when we talk about business contract agreements, especially when business contract agreements are for corporations. We're going to have some type of agent, some type of employee for the corporation to act as an agent who can then make contracts or make decisions for the corporation that are binding to the principal that they are representing in that example, that being the business, that being the corporation. Of course, there are many other examples of an agent agreement. We may hire someone in order to be a real estate type of agent in order to make certain types of decisions on a real estate. We might hire someone in legal conditions to be able to represent us in particular conditions, or be able to do things in terms of on our behalf, even if we are not present. So there's many types of agency representations, but it's the concept of having the principal who is given the authority, hiring typically someone in order to act as their representative, in order to act and make decisions for the principal. When considering the terminology of a contract, we first start with a valid contract. If we've met the 4 conditions and we say that the contract is legally valid, we're going to say it's legally valid and binding to the people involved in the contract. A void contract, then, on the other hand, is going to be a contract that has no legal effect. It's not legally binding. There's no legal consequence with the contract because it's going to be, we're calling it a void contract. Now, those are going to be the stark differences. There is some other variations here. We could have a voidable contract, and that's going to be the idea. It's not going to happen all that often or all that many times. It might happen fairly often, but obviously not as often as a valid contract, or a contract possibly that would be void in total. A voidable contract might happen when something happens to delegitimize the contract to one party for one reason. For example, if someone had a mental condition, or if someone was a minor and they went into a contract without that condition of the contract being met, they don't have the ability to enter a contract fully. Therefore, they don't have that capacity. Therefore, they don't meet the 4 conditions really in that capacity, but we still say it's voidable, meaning if the minor wanted to continue with the contract and then got consent to do so, then it's possible that we can rule that the contract could still be valid if we're saying that we have consent of the minor. On the other hand, it could be voidable by the minor, who then decides that they do not want the contract, and then say it's an invalid contract based on the fact that they are a minor. We also have an unenforceable contract, and that's going to be a contract that meets all the rules of a contract, but for some reason, for some law, it can't be upheld by a court of law. So there's something that, although the contract looks to meet all the conditions, it's not something that can be upheld in a court of law because of certain law. We also have the concept of a unilateral contract, and that's going to be the idea that one party makes a promise to do something in return for something else, meaning there's not going to be a consideration on both sides necessarily at the point of the unilateral contract, but if some condition is met, then there will be exchange. For example, if there's a contract that if you find my lost dog, then I'll give you compensation for that. Well, then that means, of course, that there hasn't been an exchange, that the lost dog isn't found. But if that condition is met, then compensation would happen at that point in time. It's important to note that a contract does not necessarily need to be an extensive written document in order to have a binding contract. An express contract would be that there is some type of agreement, which could be in writing, but it can be an oral agreement as well that is expressed. Whereas we could even have an implied contract, and that's going to be the idea that there is an applied contract by the conditions and the actions that are happening between the parties involved. So if 2 individuals are clearly acting in such a way that you would think there would be a contract in place, then we can assume that there is an applied contract in those conditions. The 4 elements of a contract will be enough for an informal contract, even if that contract is an oral contract, not in writing, even if the language is not a formalized language. There are some contracts, if we want to qualify for a formal contract, however, which may be necessary in certain conditions and may be suggested in other types of contractual conditions, would be one that we have in writing, it's signed, it's witnessed, and it's delivered. A formal contract often requires as well a seal, which is going to be some type of indication on the contract that expresses that it was accepted in a formal manner. Contracts that typically need to be in writing to be enforceable are going to be contracts that deal with the sale of land, or possibly more long-lasting contracts. If there's going to be a contract that's going to last more than a year, then these are types of examples where the written contract would be a component. And note that, of course, that if we're having any type of formal contract, it is probably a best practice, if not a requirement by law, to be a written contract. So it's important to note that it is possible to engage in a contract and not have it being in writing, so don't make the mistake. We don't want to assume that if we enter into a contract but don't put it down in paper, that then we don't have to abide by the contract. That's not necessarily true if the 4 conditions were met. However, there are some cases where we need to put the contract in writing. And on the other side of the things, if we want a contract to be as explicit as possible and probably come to the best outcomes and have both parties involved know what is expected, which is typically the goal of any type of agreement or any type of contract, then we probably would want to put it out in writing and put as explicit of terms as possible into that writing so that both parties know what is expected, so that we can fulfill the contract and everybody be happy with the results of the contract that has been put together. For more accounting information and accounting courses, visit our website at accountinginstruction.info.